14 Seegers lecture in jurisprudence. We have Professor Jamal Greene with us from Columbia Law School. He is a graduate of Harvard College and Yale Law School. He clerked for Judge Calabresi, one of the great human beings. I remember him from my days at Yale, as well as Justice Paul Stevens of the U.S. Supreme Court. He has published widely and very well, primarily in the areas of constitutional law, constitutional theory. And his research efforts have been to draw our attention to the structure of argument, the legal argument and the constitutional argument. So please join me in welcoming Professor Jamal Greene.
Thank you very much. Thank you, Bernie. Thank you to Valparaiso. Thank you to Melissa for helping to arrange all of this and make this happen. It's really a pleasure to be here. It's my first real trip to the great state of Indiana, so and it's been great so far. So I want to talk, we spend the bulk of my time talking about judicial opinions and the structure of judicial opinions in constitutional cases. For close to a century now, legal theorists, political scientists have suggested that, at least at first tacitly and later a bit more robustly, that what judges think and what judges say are not coextensive. Legal realists and attitudinalists within the political science tradition have long suggested, with varying degrees of rigor, right, that formal legal rules are epiphenomenal. That is to say, they mask the influence over outcomes wielded by the personal characteristics, the ideologies, the temperaments of legal decision makers. We can expect the influence of extra-legal factors to be even stronger in constitutional cases, particularly in cases involving questions of constitutional rights, where the outcome is so tightly bound up with deep and fundamentally divergent political commitments. The hold that this view has taken on people writing within political science is so strong that I think among constitutional lawyers, the modern debate tends to be weighted towards whether, rather than how, legal rules actually constrain legal decision makers, and constitutional decision makers in particular. Now, I'm not going to talk exactly about that debate. I want to talk about a slightly different debate, because I think that the dichotomy between, on the one hand, those factors that drive judicial decision making, and on the other hand, the public justification for such decision making that shows up in judicial opinions, obscures a different dichotomy that lies wholly within the domain of opinion writing, bearing no necessary relationship to the process of legal decision making. This is the dichotomy between, on the one hand, what judges say to explain or to justify, and on the other hand, what judges say to persuade. Within constitutional law, which is what I'm most familiar with, and which I think has some features of particular relevance to this discussion, it's too casually assumed that the standard and appropriate form of expression in judicial opinion writing is demonstrative reasoning. That is to say, a form of analysis that is aimed towards proving and justifying some known facts. In this case, the known fact being the whatever proposition the judge is trying to assert. In reality, judges writing in constitutional cases, frequently, maybe even mostly, engage what, in classical terms, we can refer to as forms of rhetoric. To the degree the moves that they make in opinions appear to be demonstrative, rather than simply rhetorical, it may be simply that logos, this is the mode of persuasion that relies on logic, just happens to be a persuasive rhetorical mode for judicial opinions. Not because judicial opinions customarily take a demonstrative form. The really interesting questions then become, what can we learn from recognizing the distinction between justification and rhetoric, whether there are constraints on the forms of rhetoric that characterize judicial expression, where those constraints might derive from, and finally the normative question, the role that rhetoric should play in judicial decision-making and in constitutional decision-making in particular. Now, to illustrate what I mean, because this has been a little bit abstract, I understand, and begin to offer some answers to these questions, I'm going to begin with 4 examples to illustrate what I mean. These are really kind of 4 discourses that have been central to constitutional theory over the last several years. And I want to suggest that understanding the distinction between demonstrative and rhetorical writing can actually illuminate and better organize what otherwise look to be a cycle of intractable disagreement within the discourses that I'm about to talk about. So, first example. The first example is something very dear to my own work. It's been very central to constitutional theory over the last 15 or 20 years. And that's the distinction between original meaning and original intent approaches to constitutional originalism. As some of you no doubt know, originalism, the notion that we should interpret the Constitution based on its meaning at the time of its enactment, was explicitly promoted in the 1980s by public officials within the Reagan Justice Department, and by academic enablers, by people at conservative think tanks, as a means of hemming in what they perceived as the activism, the liberal activism, of the Warren and Burger courts. The response from liberals within the legal academy was to attack quite directly the theoretical underpinnings of originalism as it was then practiced. There were several distinct lines of attack. One, the notion that we can divine a single original intent from the underspecified and diverse views of multiple actors at the Constitutional Convention was criticized as utterly naive and completely fictitious. Some philosophers of language, some people writing within the hermeneutic tradition, argued further that the kind of psychological gymnastics you have to go through in order to place yourself in the shoes of people living 2 centuries ago within a radically distinct culture simply can't be accomplished without importing some of our own values into the project. Legal historians, such as H. Jefferson Powell, argued that many of the framers themselves would have been, in short, appalled to learn that their understandings and expectations were being used as the basis for constitutional interpretation many years after they had died. If we accept Professor Powell's rendering of the history, then someone who looks to the framers' generation and to the framers themselves for guidance would find the framers were telling them, don't look to us for guidance. Now, a response to this academic criticism of original intent, originalism, was the proliferation of what's come to be known as the original meaning approach. Under this approach, constitutional interpretation is governed not by the subjective intentions of some amorphous group of framers, but is governed rather by the meaning of the words of the Constitution as they would have been understood by a hypothetical, ordinary person who understands the context of the Constitution. Original meaning originalism does not have the problem of determining the collective intent of a large and diverse number of people. Indeed, it has the opposite problem, if any, because it focuses on a hypothetical person, one who never actually existed. Original meaning originalism does not have the problem of being potentially foreclosed by the framers' own views and own expectations as to constitutional method. Professor Powell's article in his historical work suggests that the framers would have understood the words of the Constitution to have an unchanging meaning, right, even as they disclaimed reliance on their own subjective intentions. The broader advantage of an original meaning approach to originalism over an original intent approach to originalism is that it has a much better theorized claim to political authority. Right? The idea behind original meaning originalism is that some democratically empowered supermajority, the people of the founding generation, ratified a constitutional text. And that text had a particular meaning to that polity, so that as a best practice, what we should be doing in constitutional interpretation is seeking to understand what it is that they ratified, which is determined by an educated guess as to the meaning of the words at the time. The political authority of democratic, indeed supermajoritarian, actors is leveraged through this approach to supply a reason why their understandings are the ones that should matter. Original intent, originalism, the earlier practice, lacks this leveraging potential because no one ever ratified the subjective intentions of the framers. They only ratified the text itself. And in fact, since the convention debates in Philadelphia were not publicized, there's no written record kept that was publicized at the time, only people who were present in Constitution Hall could even say with confidence what those subjective intentions were. So it's fair to say that among constitutional theorists, original meaning originalism has won as a theory of originalism, and original intent originalism has lost. This is within the category of people who are actually originalists, which is certainly not everyone. But I want to suggest that there's more that can be said in favor of original intent than constitutional theorists tend to acknowledge. The problems that beset reliance on original intent depend on it being understood in demonstrative terms. That is, those problems depend on it being understood as being used to explain why some constitutional proposition is true. But original intent arguments might also, or in addition, be used to persuade someone that some proposition is true. And this is a different discursive exercise. Now, I think an example will be helpful here. Consider the dissenting opinion of Justice Elena Kagan in a case decided earlier this term called Town of Greece versus Galloway. In that case, was about the constitutionality of a prayer, a sectarian prayer, that opened a town hall meeting, or routinely opened town hall meetings in this town in upstate New York, the town of Greece. Now, the Supreme Court upheld the practice in a closely divided opinion, a 5-4 decision, but Justice Kagan dissented, and she argued that the prayer at issue in the case was not a neutral prayer as between religions. She said that because it wasn't neutral, it violated the Establishment Clause of the First Amendment. Now, to support this point, she dropped a footnote in her opinion that I'm going to quote in full. So, begin quote. That principle, and here she's talking about the principle of neutrality as between different religions, that principle meant as much to the founders as it does today. The demand for neutrality among religions is not a product of 21st century political correctness, but of the 18th century view, rendered no less wise by time, that, in George Washington's words, quote, religious controversies are always productive of more acrimony and irreconcilable hatreds than those which spring from any other cause. In an age when almost no one in this country was not a Christian of one kind or another, Washington consistently declined to use language or imagery associated only with that religion. Thomas Jefferson, who followed the same practice throughout his life, explained that he omitted any reference to Jesus Christ in Virginia's bill for establishing religious freedom, a precursor to the Establishment Clause, in order, quote, to comprehend within the mantle of the law's protection the Jew and the Gentile the Christian and the Mohammedan, the Hindu and infidel of every denomination. And James Madison, who again used only non-sectarian language in his writings and addresses, warned that religious proclamations might, if not strictly guarded, express only, quote, the creed of the majority and a single sect. End footnote. What was Justice Kagan doing in referring to the presidential practices of Washington, Jefferson, and Madison? One possibility, consistent with the way in which original intent originalism is sometimes understood, is that these were steps in a logical process of justifying the claim that the Establishment Clause requires government neutrality towards religion. The views and the practices of these framers demonstrate the meaning of the Establishment Clause on this view. Madison wrote the Establishment Clause, right? So his intentions on this view at least help to supply the meaning of that clause. This is very standard original intent originalism. Of course, saying that the Establishment Clause means what Madison intended it to mean, much less what Washington or Jefferson, neither of whom played a formal role in its passage, intended it to mean, would run into some of the criticisms of original intent that I've just described. A second possibility, this is a distinct possibility, is that invocation of these prominent framers was demonstrative in a different sense. It could be that Justice Kagan was actually employing original meaning originalism. And Washington, Jefferson, and Madison were being referred to as competent users of the English language, right, who were well informed as to the constitutional context. And so their views as to the meaning of the words of the Establishment Clause carry some evidentiary weight, right, just as a dictionary would, or just as a letter from a reasonably informed private citizen who doesn't happen to be president of the United States would carry the same kind of evidentiary weight. Now, needless to say, I think, the suggestion that Madison and Jefferson and Washington are being invoked just because they're ordinary, reasonable Americans who know how to use the English language misses something central to the force of Justice Kagan's argument. And so a third possibility for understanding what Justice Kagan was doing is that she was recruiting Washington and Jefferson and Madison not to supply the original definition and scope of the Establishment Clause, but to vouch for her own view, to vouch for the proposition that the Establishment Clause is neutral as between religions. Here, the choice of Washington, Jefferson, and Madison is not because, or not only because, they have some special insight into the meaning of the Constitution, but rather, or in addition, because they are recognized as great statesmen, as American heroes. It's good to align oneself with the views of such people. Right? The invocation of Washington, Jefferson, and Madison in this way would fall outside of the domain of interpretation and would move into the domain of rhetoric. References to the framers are frequently made in this way. And when made in this way, they provide a response to some of the criticisms of original intent. The problem of discerning some collective intent from numerous and diverse and underspecified sources goes away, because we're privileging those framers whose imprimatur is particularly valuable. And indeed, the easy way to know that the framers are invoked often as much for rhetorical as for strictly interpretive purposes is to consider the situations in which judges cite anti-federalists, like Brutus or Cato or the federal farmer, people who opposed the ratification of the Constitution. These were learned statesmen. We now know who they were. They were learned statesmen every bit as much as Madison or Hamilton. They have as much access to the English language and to the constitutional context. But the anti-federalists and the writings of anti-federalists are hardly ever used as positive authority to support originalist interpretation. In fact, it's easy to find instances in which anti-federalists are being used as negative authority. That is, as evidence of what the Constitution does not mean. This practice is difficult to explain except in rhetorical terms. Now, the problem of the original intentions of the framers, not supporting original intent, right? The problem that Professor Jefferson Powell pointed out, that they didn't expect us to use original intent as a methodology, is not a problem at all for someone who is using the framers for purely rhetorical purposes. The use of the framers in this way is quite independent of the particular interpretive method that one is using. Elena Kagan is not an originalist, right? But she nonetheless uses the framers to her rhetorical benefit in constitutional cases. Right? This then suggests a reconciliation of the original meaning and original intent positions. Right? Much of the time, these inquiries have two different objectives. One is designed to explain or justify. The other is designed to persuade. So they can peaceably coexist. The second example of what I mean, but ways in which we might gain something in understanding the place of rhetoric within judicial opinion writing in constitutional cases. The second example refers to the use of precedent and refers to the use of certain kinds of precedent more particularly. You all, of course, remember the healthcare litigation, right? Officially captioned a couple of things, but for our purposes, National Federation of Independent Business versus Sebelius. This is the Obamacare litigation from a couple of years ago. Now, the claimed bases for the unconstitutionality of the Obamacare individual mandate were entirely structural in nature. Right? The argument that was that requiring Americans to purchase health insurance exceeded the powers granted to Congress under the Commerce Clause, under the taxing and spending powers, and under the Necessary and Proper Clause. Nonetheless, the Supreme Court's famous, notorious, individual rights decision in Lochner versus New York made several appearances at the oral argument in the Obamacare litigation. Solicitor General Donald Verrilli said, quote, "To embark on the kind of analysis that the healthcare law's opponents suggest, the court ought to embark on is to import Lochner-style substantive due process." He said this to the court at oral argument. Chief Justice Roberts, thinking through the implications of the government's argument, said in the course of oral argument, it would be going back to Lochner if we were put in the position of saying, no, you can use your commerce power to regulate insurance, but you can't use your commerce power to regulate this market in other ways. Finally, Justice Sotomayor asked Paul Clement, who was representing the challengers to the individual mandate, whether he was advancing, quote, a Lochner-era argument that only the states can require the purchase of insurance, even though it affects commerce. Now, Lochner is an individual rights case, not a structural case. Lochner is about state rather than federal power. Lochner is about curtailing the working hours of bakers, not about forcing individuals to purchase health insurance or to purchase anything else for that matter. It had been effectively overruled 75 years prior to the litigation over Obamacare. And yet, the Solicitor General, the Chief Justice, and Justice Sotomayor each invoked Lochner. And in fact, they each invoked it for a different substantive point. For Don Verrilli, Lochner stood for economic due process. For Chief Justice Roberts, Lochner stood for inappropriate judicial line drawing with respect to congressional power. For Justice Sotomayor, Lochner stood for inherent limitations on federal power. This citation phenomenon, wherein cases are cited for reasons seemingly unrelated to their underlying facts, right, makes no sense if we understand invocation of precedent in purely demonstrative terms. Right, in the common law model, the precedent is cited in order to be affirmed as implicating similar application of law to fact, or else distinguished as relying on different facts than the case at hand. Why cite and discuss Lochner if there is no state law issue, if there's no individual rights issue, if there's no wage or hours issue? It's because Lochner is clearly being used rhetorically rather than demonstratively. Lochner is a third rail of American constitutional law for reasons having little to do with substantive due process or labor regulation as such, and having more to do with the New Deal, the Great Depression, and the popularity of President Roosevelt. Right, citation of other cases, Brown versus Board of Education on the positive side, Lochner, Dred Scott versus Sanford, Korematsu versus United States on the negative side, serve a similar rhetorical function. Their negative valence is supplied by events outside of law as such, and citation acts as a kind of epithet. Right? Mining citations to these cases for some narrowly doctrinal connection to the cases in which they're cited is often a futile exercise. They're not cited for doctrinal reasons. They're cited rhetorically. A third example. This one's a bit more tentative than the first two examples. Third example of a situation where recognizing the role of rhetoric might illuminate constitutional practice. And this relates indirectly to Lochner, and relates directly to one of the many charges that tend to be laid against Lochner, and that's the invocation of substantive due process. It is frequently said that substantive due process makes nonsense of the constitutional text, that it's an oxymoron. The constitutional scholar John Hart Ely rather memorably wrote that substantive due process, quote, is a contradiction in terms, sort of like green pastel redness. Courts and commentators have said that the notion of substantive process is absurd. Strange credulity. Liberals and conservatives say this. Indeed, Ely himself was a liberal. And his phrase about green pastel redness has in fact been cited in more than 100 law review articles. Right? Modern substantive due process is a favorite target for conservatives. Robert Bork wrote in The Tempting of America, quote, "It is clear that the text of the Due Process Clause will not support judicial efforts to pour substantive rather than procedural meaning into it." Now, the problem with these broadsides against substantive due process is that they are not true. Or perhaps it's better to say that they're beside the point. While there may well be a very strong case against substantive due process as a matter of historical argument, or as a matter of prudential argument, in terms of judicial activism, the textual case against it is remarkably weak. It is so weak, indeed, that a central point of non-substantive due process, the regular sort of due process, is that the process that one is due depends on the nature of the government deprivation. Right? Famous decisions, cases like Goldberg versus Kelly, Matthews versus Eldridge, tell us as much. More serious deprivations, so taking your life as opposed to taking your sneakers, right, might require pre-deprivation rather than post-deprivation hearing. Might require a right to an attorney rather than not giving a right to an attorney. Might require a right to confrontation versus not requiring such a right. We tailor the level of process to the nature and the scope, in short, the substance, of the deprivation complained of. This is ordinary stuff. Right? So substantive due process on this view is simply a declaration that for some kinds of deprivations, an ordinary legislative process is not a sufficient process. Right? The process that might instead be due for a law that deprives us of fundamental rights is not just legislative enactment and rational basis review by a court, but instead might be a process that requires the legislature to be pursuing some important interest, requires the legislature to be legislating through a reasonable means and fit, that requires the fitness of that legislation to be evaluated by an independent evaluator, a judge, in a case. Again, might be any number of objections to this line of reasoning, primarily based on the history of the Due Process Clause, or based on some prudential argument about how much we want judges to be involved in striking down legislation. But there's nothing in the text of the Constitution alone that makes substantive due process absurd or self-contradictory. That said, Ely's phrase, substantive due process is like green pastel redness, is so felicitous because substance and process do form a standard kind of dichotomy in legal discourse. Substantive due process suffers from a kind of marketing problem. Right? Proponents should have simply left out the word substantive, or else called it legislative due process. Right? That might put the emphasis on due, which is where it belongs, rather than on substance, which feels like it's in tension with process. Now, what does this have to do with rhetoric and what I've been talking about? Right? The idea that substantive due process is an oxymoron, or is a contradiction in terms, has significant rhetorical purchase. Right? The idea persists in part because of that reason. Right? Even if the best case against substantive due process is historical or prudential, rather than textual, right? The chuckles that you get when you say green pastel redness, or as an oxymoron, because it sort of looks like one, are worth far more to a judge or a commentator than even the most slam dunk and ingenious historical argument about the technical meaning of the due process clause in 1868 or in 1789. Final example of the ways in which understanding the role of rhetoric might help us to better understand judicial practice comes from the debate over citation of foreign law in constitutional opinions. One of the main criticisms of the use of such law is that it requires selective citation, or it in fact involves selective citation, and so it lacks integrity. Right? American judges and commentators that tend to cite the law of other jurisdictions in the course of trying to understand something about domestic constitutional law tend either to limit themselves or to be limited in any event to English language jurisdictions, limited to Western or Westminster influenced democracies, limited to jurisdictions whose opinions are sufficiently well known and sufficiently studied that they might meaningfully be cited and understood by an American judge. This is a real problem from a certain perspective. Indeed, it's a real problem from the very perspective that Justice Breyer has suggested motivates his own citation of foreign law. That perspective is what Mark Tushnet has called a, quote, functionalist perspective. In constitutional interpretation, we don't just care about text or structure or history or precedent, but we also care about consequences. This is this perspective. And on this view, other jurisdictions whose constitutional judges have handled similar cases, have somewhat similar training, provide data points. They help us uncover a range of approaches to similar constitutional questions. Those judges might be deciding questions involving constitutional provisions that are intended to meet shared or at least coinciding objectives or purposes. So we can look to these other jurisdictions to give us some data on the consequences of adopting a particular approach within our own jurisdiction. The problem with this view is that in assessing the consequences of a particular constitutional arrangement, it requires us to engage in what is essentially an empirical inquiry. And in conducting an empirical inquiry, one must be attentive to principles of case selection. Right? The cases that one selects for comparison, right, should not be based on whether a jurisdiction writes in or translates its opinions into English, or whether prominent judges from that jurisdiction happen to have run into Justice Kennedy at a conference in Salzburg, or whether they happen to have gone to a conference with Justice Breyer at Yale Law School. Right? Once we recognize that empirical questions require attention to case selection principles, the implications for a functional approach to foreign law citation might be terrifying. Right? Judges can try their best, right, to identify appropriate bases for comparison, but they have limited time and resources. the lawyers who approach the bench have limited time and resources and are in any event biased in favor of their own client's ends. The problem of selection bias haunts the entire enterprise of constitutional comparison when the objective of that comparison is understood in functional terms. The observations of this talk may offer a way out. Are the reasons for foreign law citation in the United States always demonstrative? Are they always aimed at supplying some descriptive account of constitutional practice in some other jurisdiction as a way of supplying the meaning and requirements of a domestic constitutional norm? Well, consider Roper versus Simmons. This is a prominent example of a case involving foreign law citation within the U.S. Supreme Court, 2005 case involving the constitutionality of executing a convicted murderer for a crime that he committed when he was under the age of 18. So this is the juvenile execution case. And the court strikes this down in 2005 in Roper versus Simmons in an opinion written by Justice Kennedy. He writes the opinion, he talks about various reasons why it might be unconstitutional to execute people who were under the age of 18 when they committed their crimes, having to do with their particular psychology and so forth. And then he adds a section in the opinion in which he discusses the prevalence of juvenile execution around the world. One part of that argument includes the following sentence. Respondent and his amici have submitted, and petitioner does not contest, that only 7 countries other than the United States have executed juvenile offenders since 1990. Iran, Pakistan, Saudi Arabia, Yemen, Nigeria, the Democratic Republic of Congo, and China. Now, these are all countries that are known to be deeply illiberal or to have committed or tolerated systematic human rights abuses in the recent past. One could be citing these examples functionally as a step in an argument, right, that says that continuing to execute juveniles might lead to illiberal outcomes in the United States. Right? But that's an empirical claim that would need more context, right, including, as Justice Scalia notes in his dissent, knowing something about whether the countries that have abolished capital punishment did so through judicial decisions or did so through legislation. What effects on crime control have been, or which states are unitary versus federal systems. So because practices in individual states vary, and that's important to the constitutional analysis, and so forth. Alternatively, we can understand the import of this style of citation in rhetorical rather than demonstrative terms. What Justice Kennedy is really saying is that executing juveniles is uncivilized. Right? Citing the countries that do it communicates that message viscerally rather than demonstratively. The criticism that Justice Scalia, who dissents in Roper, criticism that he has explicitly made, right, that just like legislative history, referring to foreign law involves looking over a crowd and picking out your friends, seems exactly appropriate if we understand the practice in rhetorical terms. We like and trust our friends more than our enemies or our mere acquaintances. And so we use our friends' practices to vouch for our own practices. We associate our opponent with the practices of our enemies in order to discredit and to shame our opponents. Right? This is a rhetorical exercise, an effort to persuade one's audience. Now these 4 examples, right, the divide between original intent and original meaning approaches to interpretation, the use of canonical and anti-canonical judicial precedents, debate over substantive due process and its consistency with the constitutional text, and the debate over the use of foreign or transnational law in domestic constitutional opinions, all show ways in which employing the terms of a different conceptual vocabulary can help us cut across a debate that had seemed to be kind of spinning its wheels. Now, we spend a great deal of time in constitutional law. I teach constitutional law. We spend a great deal of time taxonomizing, cataloging different forms of argument. Right? This is a very important part of constitutional practice because constitutional law needs ways of distinguishing itself from politics. Right? And one of the significant ways of doing so is by imposing limits on the kinds of arguments that count as constitutional law. So typically, those arguments are said to be limited to text, structure, history, precedent, consequences, and occasionally, according to some commentators, something called ethos. Just about every constitutional argument, every argument that qualifies as a constitutional argument, is either an argument about the meaning of the constitutional text, or about the implications from constitutional structure, or the relationships immanent within the constitutional architecture, or about historical intentions, or the contemporaneous meaning of the Constitution, or about judicial precedent or political practice, or about the consequences of a particular ruling, or the institutional legitimacy of the courts, or for the effective functioning of the government, or occasionally about the character of the American people. Right? In short, text, history, structure, precedent, consequences, maybe ethos of the American people. Scholars of classical rhetoric, right, have their own set of taxonomies. Right? The most basic one is the tripartite distinction between logos, ethos, and pathos. Right? Logos is argument based on a logical mode of persuasion. Ethos, argument based on that emphasizes the high character of the speaker. And pathos, which is argument based on persuasion by appeal to emotion. Emotional appeal as the form of persuasion. So what's the relationship between that schematic, the logos, ethos, pathos schematic, and the established categories of constitutional argument that I just suggested: text, structure, history, precedent, consequences, and again, ethos? My own view is that the forms of rhetoric complement rather than displace or challenge the traditional categories. We can think of the other modes, text, structure, history, precedent, consequences, as being domains or subjects of constitutional argument. What makes constitutional argument a distinct form of political debate and political settlement is that it channels political dispute into these particular domains. But what makes constitutional law really continuous with other forms of practical discourse and practical reasoning is that the communicative elements of constitutional law, its opinions, judicial opinions, employ logical, ethical, pathos-based, rhetorical strategies in order to persuade their audience that the propositions that they assert are valid. Right? We use logos, pathos, ethos in other forms of discourse as well. It's important for constitutional lawyers to get this right. It's easy to casually dismiss rhetoric in judicial opinion writing as either pernicious or subversive or lawless, or else trivial and unimportant, just some dressing on the opinion. But within the American system, the ability of a judge to persuade her audience that she is right forms part of the normative criteria for her performance. Put another way, the fact that a judge is unable to persuade her audience that she's correct is, without more, a reason to think that she might not be correct. Judges in the United States must constantly attend to the conditions of their own legitimacy. Alexander Hamilton recognized that in Federalist 78 when he very famously said that the judicial branch is the least dangerous branch because it has neither sword nor purse to act as a leverage for enforcement of judicial decisions. What judges do have is a jealously guarded reservoir of goodwill. That reservoir of goodwill is what lends moral force to the pronouncement of judges. It's not money or force. One of the conditions for judicial legitimacy, therefore, is some popular buy-in for what the courts are doing, some level of popular buy-in for what the courts are doing. This might be more important when a judge is invalidating rather than validating the work of the popular branches, but it's important in either event. The case for the normative importance of persuasion is strengthened to the degree that we believe that we adopt forms of popular constitutionalism and believe that dialogue between judges and social and political actors is an appropriate part of constitutional elaboration. But if persuasion carries independent normative weight in American constitutional law, then at least three somewhat unsettling implications might follow. First, what a judge says in an opinion might owe something to rhetoric. That is, it's not enough for a judge writing an opinion to explain her thinking in a demonstrative sense. Say, these are the steps of my thinking. She must also do so with at least some degree of panache, right? Perhaps even at the occasional expense of clarifying the argument. Right, now, it's possible to overstate this tension. We expect a certain degree of legalism from our judges. And so departing from that norm in some overt way, from a legalistic norm in some overt way, will in many cases undermine an opinion's persuasive effect. Right? Put otherwise, logos, persuasion based in logic, is a powerful rhetorical mode for judges. Right? And so this is not a call to abandon it unthinkingly. But sometimes, right, the best way to get one's point across is to show rather than to tell. Right? To make someone feel where you're going, rather than to simply explain it in some syllogistic way. Those of you who are trial attorneys understand this very well. So pathos, appeal to emotion, is a useful rhetorical mode even for judges. In a conventional sense, an appeal to emotion might have greater claim to legitimacy when it's in the service of persuading the reader as to some proposition within the traditional interpretive domains of constitutional law. Right? So an emotional appeal that is made as a way of advancing a textual argument, or as a way of advancing a historical argument, or an argument based on precedent, might be entirely within the pale. It seems to me to be entirely within the pale. I could give examples. Whereas a similar appeal to emotion, simply as a way of doing little more than persuading someone that some litigant should win or some other litigant should lose, unmitigated through the traditional subjects of constitutional argument. So we're not talking about text or structure or history, precedent, consequences. We're just talking about who should win or lose. That seems to me more problematic as a conventional description of what judges should be doing. The difficult question, I think, is whether the measure of legitimacy of an emotional appeal is simply its power to persuade. So that attention to the modalities of argument, to text, structure, history, precedent, consequences, and a logical exposition of propositions within those modalities is just the handmaiden of rhetoric, right? In effect, an appeal to logic in a purely rhetorical rather than demonstrative sense. Put otherwise, and put more starkly, is it appropriate for a judge to make even a logical case for a proposition of constitutional law, so long as she thinks the logical case will persuade others, but even if it doesn't persuade the judge herself, or even if it doesn't adequately explain her own analytic process? Right? This raises, I think, a second, or relates to a second and rather unsettling potential implication of what I'm saying. There may be times when rhetorical demands make it appropriate for a judicial opinion to take a certain form or even to reach a certain outcome. That is entirely at odds with the judge's own thinking. But otherwise, the significance of persuasion as part of the judicial function might well compete with or even overwhelm the significance of candor or of transparency within judicial opinion writing. In some sense, I think a lot of us intuit this to be true. Consider, for example, the role of religious conviction in judicial decision making. We might or might not think it's appropriate for religion, or the personal religion of the judge, to influence how a judge approaches a constitutional issue. But A committed legal realist or attitudinalist, by the way, assumes that this is always going to be true and that there's nothing the judge can do about it. But most of us agree that whatever role the judge's own personal religious conviction plays in the process of decision making, it should play no role in the opinion the judge writes. To find the opinion less persuasive as constitutional law, right, if it included religious elements in its written presentation, if it said the reason why the Constitution means thus and so is because the Bible said it. Right? At this point, we have to pause, right, to consider the nature of the judicial audience. Right? I say we would find such an appeal to religion and constitutional argument less persuasive, less convincing. But what I mean by we is the professional legal elite. Right? And so a third possible, and if true, potentially unsettling implication of the argument, if we believe that persuasion carries independent normative weight in constitutional opinion writing, we have to consider the possibility that those who ultimately need to be persuaded are not just legally unsophisticated, but also might have illiberal ends or objectives. And here I'm not contrasting liberal with communitarian, I'm contrasting liberal with parochialism or chauvinism. Now, in fact, the choices are unlikely to be so stark. I suspect that if the American people were in fact illiberal in some higher law, in some deep fundamental sense, if they were in fact not committed in some deep sense to a culture of rights, then we would find judicial review intolerable. And so when we speak of rhetoric and the demands that persuasion places on the judicial role, I think we have to understand the object of persuasion to bear not necessarily on the individual outcome in any particular case, but rather upon the consistency of the opinion with conventional understandings of the judicial role. Political scientists distinguish specific support for institutions from diffuse support for institutions. Specific support might be support for the specific decisions of a court. Diffuse support is support for the institution more generally, and diffuse support is less sensitive to particular decisions. There's a certain inelasticity to diffuse support that suggests a margin of appreciation given to courts to reach decisions that members of the polity might disagree with on their particular terms, or might find unpersuasive in their specifics. So I close with an observation about the degree to which this talks, claims are contingent upon a particular culture, a particular judicial culture, a particular kind of constitution. The case for persuasion carrying independent normative weight depends on understanding constitutional law as being in dialogue with the polity. This is a contested view, even in the United States. Although I think it's difficult to dispute, and I think you'll have a hard time finding an empiricist who would dispute, that it's accurate as a descriptive matter, that constitutional law is in constant dialogue with popular opinion. Now, many civil law jurisdictions distinguish quite sharply between ordinary legislative power and what is sometimes called constituting power, pouvoir constituant. Constitutional revision requires activation of that constituting power. And so the role of a constitutional judge is to keep faith with constitutional law as codified by those who are authorized to exercise that constituting power, and that's not ordinary present majorities. Now, this is an idealized view of civil law, the civil law court, but I think it's increasingly detached from the reality of Kelsenian constitutional courts and the degree to which precedent in those courts is actually today invested with a certain amount of legal authority. But the point here is that a constitution that is viewed in different terms than the American Constitution, and in particular a constitution that's viewed either in large measure in technical terms, or one that's viewed that's not associated pervasively with a particular national identity, seems likely to place relatively weak claims on persuasion, right? Less likely to give rise to a judicial culture that gives rhetoric a long leash. Right? One's Frenchness, right, does not depend on acceptance or affiliation with the 1958 Constitution of France, in the way that one's Americanness might be said to depend, at least in part, on one's affiliation with the set of political commitments embodied within the US Constitution. Under those circumstances, the kind of dry, syllogistic reasoning that we see in French courts, including in constitutional cases, might be good enough for that constitution, for that kind of constitution. Notice, though, that this might be characterized simply as different weight that other jurisdictions might attach to logos, as against pathos or ethos, in assessing what counts as persuasive for judges. Right? So maintaining consistency with the conventional judicial role might well make normative demands on opinion writing quite apart from one's theory of the relationship between the people and constitutional law. If that's true, then the application of these observations to US constitutional law might simply make a stronger case for attention, or a particularly strong case for attention to rhetoric that then would exist under a different kind of constitution. It's not as if one must never pay attention to rhetoric in other kinds of constitutions. It might just be that the claim is weaker, and stronger given the nature of our particular constitution.